Welcome to Chapter 3, Medical, Legal, and Ethical Issues. In this chapter, we're going to talk about those things that can kind of get us in a little bit of trouble legally, morally, and even ethically if we're not careful as an EMT. So there's a basic principle of emergency medical care is to do no harm. So our purpose is to actually help others, and when we cause harm to others, that's a problem. So a healthcare provider usually avoids legal exposure if they act in good faith and according to an appropriate standard of care. So that's our best bet for avoiding getting ourselves in trouble. Also, one of the best things that we can do is make sure that we provide competent emergency medical care that conforms to the nationally recognized standard of care. So, did I skip one there? No, sorry. Consent is one of the first things that we need to consider when we're talking about medical and legal aspects. A person, before we can care for them, needs to give us their consent or permission to take care of them. If they're unable to do that, there's some other special situations that apply or special circumstances that apply. But it is very important that a person gives us consent before we begin to treat them. They're not able to give us consent if they're unconscious or they're irrational or they're incapable of making informed decisions. So they need to be conscious, rational thinking, and capable of making an informed decision about the care that we are going to give them. One of the most easiest to explain forms of consent is express consent. Basically, the patient basically says, "Yep, you can treat me." They give you expressed consent. That still means that the EMT needs to explain the treatment, the risks and benefits, and all those kinds of things that they're going to do. And only after that can the patient actually give an informed consent for what you're proposing or what you're offering. So express consent is quite simply when the person is conscious, they're rational thinking, and they're fully capable of making a decision about their own care, and they give you expressed consent. Now, the thing where it gets a little bit sticky is if there's somebody that's under legal age, if there's somebody that's under 18 years old, there gets to be a little bit of confusion in there. Generally speaking, if this patient that you're caring for is over the age of 16 and perhaps driving a car, sometimes we can get away with letting them say yes or no. Yes, they want to be treated, or no, they don't want to be treated. But usually with younger age groups, we oftentimes don't allow them to make that decision entirely. To a degree they can, but not entirely are they able to make that decision completely on their own. Now, when we do have a patient that is unable to communicate with us or speak to us, or they're in some fashion or form cognitively not able to make a decision, or we don't feel like they can make a rational decision, we operate under the rules of implied consent. This is unconscious patients, or like I said, those people that are unable to make an informed decision because maybe they've got some sort of a head injury and they're not thinking or acting rationally, or maybe they haven't taken their medication and they're just kind of out of their head. And this is only used when there's a threat to life or limb. So just because we think they should go to the hospital and get checked out doesn't necessarily mean that it falls under implied consent. It's only when we are thoroughly convinced that harm's going to come to this patient if we don't take them to the hospital. Because a rationally thinking person, the premise is a rationally thinking person would want us to take them to the hospital. So this is, when we're dealing with implied consent, we have to be careful a little bit here. Is we're not just taking them to the hospital to get kind of checked out because they got a little boo-boo. We're talking about life and limb. So if somebody says, "I don't want to go to the hospital," and they got a little bump on their head, it has to be life and limb has to be in place in order for us to use the implied consent rule. This is also known as the emergency doctrine, which basically says a rationally thinking person would want to be cared for. Um, Involuntary consent applies to patients who are mentally ill. They maybe have a behavioral crisis or they're developmentally delayed. Um, uh, these are patients who need medical attention, who may, because of their behavioral or their mental abilities, may deny giving you consent or are not able to give you consent. Basically, what happens with this group of people is they have some sort of mental illness, a behavioral crisis, or they're developmentally delayed in such a way that the courts would say they're not capable of either giving consent or not giving consent. They can't give it either way. And basically, if we try to get consent from a guardian, but that's not always possible. So we need to be careful when we agree to take them to the hospital or not take them to the hospital. Um, uh, Obviously, having a guardian saying yes, please take them, or no, they're okay, I don't need you to take them, is helpful. In the event that you don't have that guardian there, you're always going to have to default to taking them to the hospital. You'll always default to doing what is the absolute best, in their absolute best interest. And that's always going to be letting a doctor see them. So it may be a little frustrating where you don't necessarily think they need to go to the hospital, but there's nobody there to say, I got them, I'll take care of them. And that needs to be a guardian, not just any person. It needs to be somebody that is a guardian of them. Minors and consent raise an interesting issue. Like I spoke to a couple of slides back, it can be problematic, because what is that age that they can consent? Is it 18 years old? Well, what if you have a 15-year-old with with two children of her own? It seems silly, but it does happen nowadays. Is that 15-year-old not capable of giving consent or not giving consent? So there's some issues there that we usually have to work around, and we have to be cautious. Most of the time what we'll do is whenever there's a question about it, we'll contact either our medical director or the physician in the emergency room and let them help us with that. Now, of course, if there's a guardian there, a parent or a guardian, they're the ones that can give consent for anybody that's under 18 years old. In some states, if they're emancipated minors, such as the 15-year-old with one or two children, they're technically emancipated because once you have a child, you're self-considered an adult. Generally speaking, that's not always true, so don't think that always applies. Obviously, if you're 11 or 12 years old and you have a child, you're still a child yourself. So it's not always a perfect world. Like I say, the best thing that we can do is to contact medical control and see what they recommend. Sometimes teachers in schools can act in the place of parents because generally we see teachers as going to act in the best interest of a child, and that's typically the case. So sometimes they can make some consent. They can speak to consent sometimes. But if a true emergency exists, no consent is available, we need to treat the patient under implied consent. So if it's a true life or limb situation, we don't need anybody's permission. We just treat that patient because if mom and dad was there, they would want us to treat the patient. So that's kind of the premise that we work under. Sometimes mom and dad doesn't understand that it is a true life and death event. And if they're saying, no, I don't want you to take them, that's probably a time when you're going to have to get law enforcement involved, because if you just take them, you're going to create bigger problems and make things worse. Definitely when you run into those issues, it's always best to get somebody in another uniform out there, police officer, sheriff's department, somebody like that, helping you work through those situations. So sometimes it's also necessary for us to forcibly restrain somebody. Sometimes patients are combative, they're violent, whether it's because of a head injury or drugs or any number of things that can cause this. But these almost always involve law enforcement, and they should always involve medical control. There's generally, as an EMT, the type of restraints that you'll use are the restraints we see on this guy. He's got some arm restraints on, it's kind of holding him down. It's actual physical restraints. There are what's called chemical restraints too, where they use a medication to sedate a patient to restrain them with a sedative. So you may be involved in something like that. You yourself won't be able to do that, but you might be working with a paramedic or working with a physician that orders that in the emergency room that you might need to assist with. So two different types of restraints are physical restraints and chemical restraints. Patients do have the right to refuse treatment. A conscious, alert adult has a decision with a good decision-making capacity can refuse treatment, or they can withdraw treatment. They can refuse certain types of treatment. They can say, "Yeah, I'll let you take me to the hospital, but you're not starting an IV." They are well within their rights of doing that. But we need to make sure we assess the patient's ability to make that decision. If they're confused, delusional, suicidal, we can't just take it we can't just let them make that decision. They need to understand the danger for refusing that care. Obviously, a suicidal patient, they really don't care if it's dangerous to them. That's kind of the point. So they're unable to make that informed decision for treatment or to refuse that treatment. Before you leave the scene where a patient, parent or guardian has refused care, try to encourage them again to allow you to treat them. Ask them to sign a refusal of care form. There's a form that you'll have them sign that says, "Hey, I don't want care." If they're a minor, you make sure that you have the parent or guardian sign that. And of course, you should get some witnesses. So if there's any other non-EMS personnel around there, have them sign and witness that. Another expert person or another professional person witness that refusal of care. Make sure you carefully document that refusal. You still want to document your findings, what you found with the patient, that you recommended them go to the hospital and why, and all of those types of things. You still need to do as complete of an assessment as you can, but you also have to realize that this person is refusing care, so you're not going to probably be able to put your hands on them. So most of your assessment's just going to be visual of what you can see. Of course, providing treatment is much more easily to defend than failing to provide treatment to a patient. So, but you can also cross the line and forcibly force care onto a patient and wind up battering them or restraining them and imprisoning them, and then you wind up into a whole host of other legal problems. So we want to try to get that consent, but they do have the right to refuse that consent. One of the biggest things that we need to make sure that we protect is our patient's confidentiality. And we're bound by law to protect a patient's confidentiality. And that includes their personal history, what we found, what treatment we gave. And this patient information can be disclosed at certain times. But that's only if the patient signs a release that says, "I give you permission to release my information." We do that with almost every patient that we're going to bill their health insurance company. If they have a health insurance company, we have them sign a form that says, "I give you permission to release my medical information to my health insurance company for purposes of payment." We do that. There's also other forms that they can sign, after the fact, that if, attorneys or police departments or whoever needs their patient information or that run form with their personal information on it, they can sign that release. We can also get a legal subpoena that requires us to release that information either to the courts or to the police or to the district attorney. And it's also needed by billing personnel to bill medical billing. So the act that protects them was passed in 1996, and we affectionately call it the HIPAA Act, but it's the Health Insurance Portability and Accountability Act. There's a section in there on patient privacy, and it wound up strengthening privacy laws, and it provided some safeguards for confidentiality. And it defined what protected health information was, such as name, date of birth, allergies, medications, all of those personally identifiable things, a way that someone could identify who you were and personal information about you. It protected all of that. Confidentiality is a big deal. And we live in the information age where everybody wants to put everything out there on Twitter or Facebook or Snapchat and all those different types of social media places. My recommendation is you don't put anything on social media for your entire shift that you're at work. And when you get off work, you don't talk about work on your social media ever. If you follow that rule, you'll be okay. But it's where you get into problems is when you put something on social media that says, hey, went on this call yesterday, and you don't even have to say where it was. But if you say what it was, then somebody on social media can go, oh yeah, you went to so-and-so's house and you just told me what was wrong with them. And, then you start creating problems for yourself. I'll be honest with you, people get fired on the spot for violating confidentiality. So nobody needs to know somebody else's business. Stay off of social media while you're on shift, and when you're off shift, don't talk about what went on while you were on shift. Don't talk about the calls you went on, where you went, what it was, or anything. Keep it to yourself. That's part of becoming an EMT, is you're trusted with some very personal and private things of the people that you care for, and it's your job to protect those things. There is also, you may come across, or you will eventually come across, what's called a do not resuscitate order. And this do not resuscitate order is a physician's written order to withhold resuscitation efforts. Basically, we don't do CPR, breathing, and all that for somebody, but it doesn't mean don't treat them. So if you have somebody with a do not resuscitate order, but they're alive and breathing and talking and all those kinds of things, or mostly alive, we're still going to treat them. Do not resuscitate means when somebody is in a state that they are, not breathing, or their heart's not beating, it means we're not going to try to resuscitate them. It doesn't mean that if they have pneumonia, we're not going to treat them. We will definitely treat them. Generally, do not resuscitate orders will have statements in there about the patient's medical problems, signatures of the patient and legal guardian, signature of the physician or healthcare provider, and they generally don't expire. A do not resuscitate order is an order from a physician, but the patient or a guardian has to sign off on that as well. And it's usually a pretty straightforward document. It's a one-page document, and you'll see basically a statement that says, here's what's going on. If they're found in this state, don't do anything. And then you'll have signatures underneath that, and it'll be dated, and it usually doesn't expire. That's different from an advance directive that specifies certain things. Basically, it says, should a patient be unable to make decisions, these things are what can be done. This is what I want done. Physician orders for life-sustaining treatment, medical orders for life-sustaining treatment, a list of acceptable interventions. Advanced directives, interestingly enough, don't involve a physician. It's a legal document drawn up by an attorney, and then it's signed by the patient and whatever witnesses. It covers those things, such as if you're a long-time respiratory patient that's had respiratory diseases for a long time, and you go into the hospital, it says, yeah, treat me, take care of me, but don't put a breathing tube in me and put me on a ventilator. I don't want that. If it comes down to that, just let me go. So that's that kind of advanced directive that says, do this, don't do that. That kind of a thing. And sometimes those documents can be very lengthy, very long, and difficult for you to read and interpret, because they're written by attorneys. I would say that if you come across one of these and you got family members pushing this in your face saying they didn't want this done, they didn't want that done, say, look, I understand that. I don't have time to read that. That's a legal interpretation of that. We're going to do these things and take them to the hospital. When there's time for this to be interpreted, they will take those things away. They will stop those things. But don't let yourself get in a position to where that you're slowing the delivery of care because you're trying to read a 15-page document that's written in legalese that technically you're not even really qualified to read. So it's difficult for family members to understand that sometimes, but just be careful that you don't, hamper patient care because you were reading a document. Sometimes we're going to come across patients that are obviously dead. When we come across those patients, we're not going to do anything for them. We're actually not even going to transport them. In Oklahoma, it's illegal to transport somebody, a dead body, by ambulance. And if you've pronounced somebody dead at the scene, you're not going to transport them anywhere. You're going to let the funeral home do that. So there are some obvious signs of death. And the little bit of a misnomer here is EMTs and paramedics can't pronounce somebody dead. What they do is they find all of these signs of death and they contact either the medical director or the emergency room physician and they say, hey, look, here's what we've got. And the doctor on the other end of the phone says, yeah, they're gone. And that particular doctor is the one that pronounces them dead because they have a license to be able to do that. Our license doesn't allow for that. So we come up on the scene and we find somebody that's unresponsive. They don't have a pulse. They're not breathing. No reflexes, no pupil activity, no blood pressure, profoundly cyanotic or they're blue, and they have a lowered or decreased body temperature. Those are all pretty good indications of death. But there's also some others, there's some where bloods begin to pool, in various parts of the body. And we get, it looks similar to this because of where the blood has pooled. We can also see, it's kind of funny, you see a handprint right there in the small of their back too, from probably where they rolled them over, where that, it's not anything criminal that happened there. It's just where they put their hand on them to roll them over. So some obvious signs of death are, decapitation, dependent lividity, this blood pooling or settling like we see in this photo, rigor mortis where they're stiff, or decomposition. Those are some obvious signs of death, and we're not going to try to any heroics to try to save somebody that's obviously been dead for some time. And those are instances where there's really not a whole lot. Even calling your medical director or the emergency room doc, they're dead. I mean, they're dead. So there's not a whole lot of need for that. But oftentimes, as new or early EMTs, first off in your career, I always say call first. Call that medical director. Call your emergency room doctor. Let them know what's going on. Tell them it's obvious signs of death. Sometimes the patient's physician will sign off on the death certificate as opposed to the emergency room doctor if they're under a physician's care. But regardless, there's no saving that, and there's no sense of going to all that extremes to try to save somebody that's long been gone. So sometimes these cases of unattended deaths wind up being a medical examiner case. If they're dead on arrival, when they arrive at the hospital, or dead at the scene, depending on the circumstances that surround that particular thing, age of the patient, if they're under a doctor's care, all these types of things may determine whether or not the medical examiner gets involved. Many times when I would go on an unattended death, the medical examiner was the first person that I talked to after I said, yeah, they're obviously dead. And then next thing I know, I would be on the phone with the medical examiner, visiting with them about what we found at the scene, what was going on, what we found with the patient, if we suspected anything such as that. They would make a determination over the phone, if possible. If not, they would come on out. But if they said, hey, look, yeah, we're going to it sounds like this is all natural, let their own doctor take care of it. A lot of times, though, they would come out to the scene and do their investigation. And this is especially true if the patient didn't have a personal physician, regardless of their age. If they didn't have a personal physician, oftentimes the medical examiner would step in so that they could determine a cause of death. Suicides, violent deaths such as murders and all those kinds of things. Poisonings such as known or suspected. Death from accidents, drowning in a pool or car accident or something like that. The interesting thing about car accidents, rarely a medical examiner case. A lot of times, they play out differently than finding somebody that has been deceased for some time in their home and in their bed. A death from a car accident. Usually, the funeral home will pick them up and take them to the medical examiner's office. Any criminal acts, infant or child deaths, or young person's death oftentimes winds up being a medical examiner case because they want to know what happened and if there was a crime that was committed. So they'll look into that to determine if there is something that the state needs to know about, whether it's something they need to prosecute or the health department needs to be aware of, in case it's some weird form of, Ebola or something, who knows. You will from time to time come across organ donors. They'll usually on the Oklahoma driver's license, or the organ donor has I believe it's a little heart on the front of it, right, and the bottom right. If they've got a little heart there, that means they're an organ donor. Typically for us in EMS, that doesn't mean a whole lot. It doesn't really change what we do necessarily, just because it just doesn't. What it does change is sometimes what happens in the emergency room or ICU or critical care places, that kind of thing. If the person is considered brain dead or something like that, and they want to potentially harvest the organs. We oftentimes think about car accidents and all that kind of stuff, but usually car accidents, if somebody dies in a car accident, usually the violence is so great that the organs are typically not salvageable. So that's why it's uncommon for organ donation to come out of a car accident unless it's isolated, only a head injury and the rest of the body seemed intact, that kind of thing. So I know that's kind of morbid to say, but generally that's the case. But you may be involved in that, so your priority is to save the patient's life, not necessarily worry about organ donation. But realize those organs need oxygen, so we need to keep the blood circulating and the oxygen getting into the tissues. So that's going to be the priority. Also, we should look for medical alert bracelets or necklaces or keychains, cards indicating do not resuscitate orders, allergies, or medical conditions that they may have. Some patients wear a medical bracelet that has a flash drive on it nowadays. So look for these things during your assessment of your unconscious or your patients that have altered levels of consciousness. We need to look and make sure that they don't have one of these bracelets that might give us some indication of what's going on with them. Might be a diabetic or something like that, that we could treat, that would be helpful in knowing. So it's important for you to understand and know your scope of practice, because it outlines the care that you're able to provide. This class that you're taking follows that scope of practice model. We're not going to teach you anything that is outside of the level of license that you're going to have or outside your certification level. Usually these are defined by state law, as the slide says. Well, I'll tell you that Oklahoma state law follows the National EMS Education Standards, or the National Scope of Practice model when it comes to EMTs. So it's the national model. And you can actually go out there and find that scope of practice, and you can find the national EMS education guidelines for EMT at the website www.ems.gov, ems.gov. You can find all of those things out there. I encourage you to go look at it. It might be helpful in you knowing what you're limited to do, but you're not going to find test questions out of that document. I'm not going to do that to you. Sometimes the medical director can further define that scope of practice, and they do that through those protocols and standing orders that we talked about. Also, there are rare instances in Oklahoma where the state has allowed certain levels to do things that were actually the next level up because of extenuating circumstances. But it required significant training and documentation, and a medical director willing to sign off on that in order for that to happen. And it does require state approval. I'm trying to think of an example right off the top of my head, and I can't think of any. I believe at one time some EMTs in one part of the state were being allowed to administer breathing treatments to certain breathing patients under certain conditions and that kind of thing. I don't know that they're able to anymore, but it's just those kinds of things that's out of their scope of practice that is allowed by the medical director. But you as an EMT, anytime you're acting outside of the scope of practice, you lose that national cover, meaning you're kind of acting a little bit rogue, even though the state and your medical director approves it. You don't have that national practice act to fall back on if something legal happens. You don't have that to fall back on and go, look, I'm under the national practice. It's within my scope of practice that I'm doing that. If you're doing a procedure that's outside of that scope of practice, even if the state approves it and your medical director signs off on it, you still don't have as much cover. You're covered, but you don't have as much. It's just, there is some risk there, though the risk is pretty low. So there's also some standards of care that we need to follow. And basically that's the manner in which we must act or behave. And we measure that by what a reasonable EMT would do in a similar situation. That's kind of that standard of care. And this is not something that's typically written down and defined clearly. Basically, there's some local custom that comes into play on this. Laws, professional institutions and standards, textbooks, some standards imposed by states is how we come up with this standard of care. So basically here in Oklahoma, all of the EMTs do a very similar standard of care. It's very similar to in what they do, and it really kind of follows that scope of practice model. These are the things that you're allowed to do, so these are the things you're expected to do. There are some things that can come into play in this, such as local laws and customs and things like that can limit us. For instance, on the national scope, paramedics are allowed to administer I lost my train of thought. Lasix. They're allowed to administer Lasix on a national level. But here in Oklahoma, the state medical director, the medical director for the entire state on the EMS side has said, I don't want them given Lasix. So that's something that's different, meaning if you were in Texas and you had a patient with congestive heart failure that had a bunch of fluid in their lungs that could be treated with Lasix, and it may actually be life-saving to give them some Lasix, and you do that, you're fine, because it's within your scope of practice. If you do that in Oklahoma, you would get in trouble for doing that, first of all, and you could potentially get sued by the family for not doing it, because it's a national scope of practice model that's acceptable to do that, but in Oklahoma it's not. So it's doubtful that as a paramedic you would get sued for not doing that because you're following what the laws are, but it would cause some controversy at the state. Now, I drew out this scenario to make it sound really dramatic, but truth is that's been in effect for some time now, and it's really not caused any problems across the state. So it's rarely is it an issue because typically these sorts of things are pretty well thought out. And, the training is there, if it's something new that's added. So as an EMT, you do have a duty to act. When you get a call, you're on duty, you're working, you get a call, you have a duty to act. You need to respond to that call. When you respond to that call and when you begin treatment, you have started that duty to act. So basically, if you're at work and you get a call, you have to go. It's not, you don't make a judgment of, well, is that important? Is that not important? I don't want to go right now. Nothing like that. You have a duty to act. You go. Because if you don't, if you fail to provide that standard of care, if you fail to act, you've basically committed negligence. So in order for a negligence case to go through, all four of the following things need to be present. Was there a duty to act? Did you breach that duty? Were there damages? And were the damages a direct result of your failure to act? So, for instance, you get a call to a car wreck and you go, hey, look, I'm in the middle of watching this movie. I don't want to go. So was there a duty to act? Yep, there was a duty to act. Did you breach that duty? Yep, you stayed and watched TV. Were there any damages? Well, somebody died because they didn't get treatment. Well, was that their death a result of that, of not getting treatment? Yeah, because if somebody would have gotten there and put a tourniquet on their left arm, they wouldn't have bled to death. So that's the elements of what a neglect case would be. If any one of those elements don't exist, then there's no negligence case. So same scenario, car wreck. Was there a duty to act? Yep, there was a duty to act. Did they breach it? They breached it because they didn't go, they stayed and watched the movie and they didn't go on the call. Were there damages? Yes, there were damages. The patient died. But were the damages caused by the medic not going? Well, actually, that patient was decapitated in the car accident, so they were dead before the call even came in. So the cause of the damages was not caused by the medic not going on the call. So there wouldn't be a negligence case. Of course, that medic would not have a job, and there would be all kinds of other problems. They'd probably lose their license and all that. So just because there's not negligence doesn't mean that there's still not some criminality to it. It just means that they're not going to get sued for that. But all of those elements need to be in place in order for negligence to happen. And negligence usually results in, sometimes it'll result in criminal charges, but typically it results in civil charges where there's a big lawsuit, that kind of thing. Abandonment, of course, it's a unilateral term for termination of care by the EMT without the patient's consent or without making provisions for continuing that care. So basically, you're taking care of a patient and the patient doesn't say, yeah, I'm good, thanks, or you don't pass that care on to somebody else. This can be actually very simple. This can happen very easily. And these are the things that we need to be careful of. You go over, you're at a car wreck and there's 6 patients. You go over and you start to care for a patient. You walk away and go care for another patient. You walk away and go care for another patient. You could have technically abandoned the first 2 patients that you've come in contact with. Now, that's very extreme because when your resources are limited, that would be difficult. That'd be a difficult case to prove in court. What wouldn't be difficult is you pick up a patient at their home or wherever, you take them to the hospital, you wheel them in, put them on a bed in the, an emergency room bed in the hospital. You haven't seen a nurse, a doctor, anybody, nobody nowhere has come to you to talk to you about this patient. You clean up your cot, put your equipment back together and leave without talking to anybody at the hospital about this patient, then you've committed abandonment. Even though that patient is at the hospital, you've committed abandonment because you didn't make provisions for the continuance of that patient's care. You have to make those provisions, and the way you do that is you hand off the care of that patient from one provider to another. Simply assuming that someone's going to take care of them won't do the trick. So abandonment can take place at the scene of a call or while you're dropping them off at the hospital. So you got to be careful about that. Always obtain a signature of the patient care record. So whenever you drop that patient off at the hospital, make sure you have a nurse sign, or a doctor sign that, hey, look, we've transferred the care over. That'll help with that. That'll help keep that from happening. Assault, battery, and kidnapping. It is possible for you as an EMT to commit all of these in one call, even with the best of intentions. Basically, you assault somebody by unlawfully placing a person in fear of immediate bodily harm, such as restraints. And battery is unlawfully touching a person, providing care without consent. So you can see how easily this can happen You can assault and battery somebody simply by forcing them to go with you to the hospital or beginning to care for them against their consent. And then when you load them up in the back of your truck, you kidnap them because you seized, confined, abducted, or carried away by force a person, basically transporting them against their will. Also, this would qualify for false imprisonment, which is unauthorized confinement of a person. Basically, the person rescinds their consent, but the EMTs don't let the patient leave the ambulance. So they have the right to, halfway to the hospital, refuse consent, to decide that they don't want to go with you no more. And you have to honor that. Pull the truck over, let them out. That's the way that works. Defamation can also be a problem. It's basically communication of false information that damages the reputation of a person. Libel is usually a written form of basically a false statement on a run report, can get you in trouble there. Or slander is something that is spoken or made during a conversation. Remember, when you're writing run reports, they should be accurate, to the point, relevant, factual information. No conjecture, no feelings, no I think they meant, or I think they did, or I don't like their, or nothing like that. It's all actual, accurate, relevant, factual information about what went on during that call, and nothing that is your opinion about what's going on, just factual information. There are some laws that protect us, though, the Good Samaritan laws. When we act in good faith, and especially when there's no expectation of compensation, so we stop at a car accident on our way home from work and we're not being paid, but we also act within our scope of practice. So you can still do some of those things that you do as an EMT outside of working, so long as you do it, it stays within your scope of practice, and you don't do it in a grossly negligent manner. You can still be covered under the Good Samaritan laws. Now, the Good Samaritan laws don't always extend to you when you are working, because you're receiving compensation for what you're doing. There's still some, it still will apply to a certain degree, but not entirely. So it won't give you complete coverage. Of course, gross negligence is basically conduct that constitutes willingness or reckless disregard for a duty or a standard of care. Basically, you do something completely wrong that you know you shouldn't do. It's grossly negligent to do something like that. Let's say you've got somebody, you're an EMT, and you've got somebody that's not breathing, and you think you need to cut a hole in their neck and put a tube in there to help them breathe. Well, that would be grossly negligent because it's outside of your scope of practice, and you got no business doing that. That can get you in big trouble. Remember, whenever you do something that's outside of your scope of practice and you're doing that off duty, there's no coverage for you. Whatever you do makes you personally liable. So most of the time I recommend to EMTs that they don't do anything beyond very basic first aid, meaning if somebody's bleeding, cover it. If they got something broken, splint it maybe, or just hold it until help gets there. You're not doing any major heroics or anything like that. It's very basic first aid until other help gets there, because the more you do, the more you open yourself up to that liability, and you don't have anybody protecting you. Meaning, if you get sued for $1 million and they win, where are you going to come up with $1 million? Because you don't have malpractice insurance when you're not at work. So be very careful about Good Samaritan and stopping and helping. I'm not saying don't stop and help. Actually, you should stop and help. But you should only provide basic, or not even basic, just some simple first aid, and controlling the scene kind of things until, the guys that are on duty arrive. That'll keep you out of hot water. Important to have good reports and records. This was covered in the document. They'll be covered in the documentation chapter coming up next. But it's very important that they're very thorough. The courts look at if it was an action that was recorded and not performed, or incomplete or untidy reports are evidence of poor emergency medical care. So when they look at your documentation that you make about caring for a patient, they look at all of those things. If you're sloppy, misspelled words, poorly taken care of, they're going to think, well, this is an indication of the kind of care that they provide for their patient. Could be completely untrue, but that's the appearance that it gives. So if you write something down that you didn't do, or you do something that you didn't write down, that all hurts your credibility in the long run. So it's important that you document things properly and leave out all of those personal feelings and all that kind of stuff. It needs to be factual, very direct, those kinds of things, because that makes you look like a professional in the eyes of the court and in the eyes of attorneys that are either trying to put somebody else in prison or trying to get some money out of you. So be careful about your reports. There are some times that there are some mandatory reporting requirements beyond filling out a run report that you turn into your boss. If you have child or elder abuse situations, those need to be reported to the appropriate state agency, such as Child or Adult Protective Services. If there's an injury that involves a felony, of course, law enforcement needs to be involved, such as you get called and you discover that it's a domestic abuse situation. You need to make sure you let the authorities know. Drug-related injuries, childbirths, just a simple, even though childbirth isn't simple, but a childbirth needs to be reported. Suicide attempts, dog bites, certain communicable diseases will have to be reported, and usually those go to the Centers for Disease Control. Assaults, domestic violence, sexual assaults and rapes, exposure to infectious diseases, patients that you had to restrain, crime scenes, deceased patients. So there's a lot of things that need to be reported. Some of these things happen automatically. Others, it's going to take an act by you in order for it to be reported. Sometimes domestic violence, sexual assaults, and rapes, you need to be the one to raise the red flag. Same with child abuse and elder abuse. Often, very rarely are you contacting Adult Protective Services. Most of the time, it'll be law enforcement. You'll notify law enforcement and say, hey, I think we got a child abuse case. By getting them involved, they have detectives and all that kind of stuff, and all the resources that you don't have. Your job there is to care for those that need cared for, not to get the bad guy. Get the police in, they get the bad guy. If you want to be the one that goes out and gets the bad guy, then you need to go to policeman school and not EMT school. So that's the difference. Report those to either law enforcement. If it has anything to do with any kind of violence or anything like that, it's law enforcement, it's the police. It has anything to do with kind of the medical side of things like diseases and a randomly deceased patient and all that. That's probably going to be something that emergency room personnel will handle, or another entity. Very rarely is it us on the scene that's dealing with a lot of those things. Ethics is a big deal in EMS. It's a big deal in anything medical. And ethics can be difficult to define and difficult to put your finger on. But ethics is basically the philosophy of right and wrong, those moral duties and ideal professional behavior. Ethics are something that you have that are inherent to you, that you come to this EMT class with, in your philosophy of what's right and wrong, how you should treat others, all those kinds of things. Those are ethics. Those are your philosophical ways that you handle yourself in life. Well, our profession has some ethics as well, some things that you're expected to do and ways that you're expected to behave. And those are those ethical things. Basically, those are the things that you're going to learn throughout this course. You're going to have a good understanding of the ethics and the ideal professional behavior that you should exhibit, and the moral duties that you should have. Morality is basically a code of conduct that affects character, conduct, and consequences. Your ethics are kind of your personal philosophy. Morals are kind of what you've learned, and morals actually kind of guide your ethics. I know it can get really far off into the weeds, and there's entire college courses on ethics, morality, and bioethics. Bioethics has to do with the issues that arise during the practice of health. So while you're out there, sometimes you're going to run into ethical dilemmas. And if I would have thought, I would have come up with one before we would have gotten to this slide. But, you're going to run into all kinds of ethical dilemmas where I'll give you one. For instance, we had a patient that was obviously suffering from a cardiac event. And the cardiac event was very serious, and they were going to die if they didn't get care. They didn't want to be care. They didn't want care. They didn't want help. They didn't have a DNR. They didn't have an advance directive or anything like that. It was just this elderly person or older person, I don't say elderly, I think they were 60s, that said, look, I don't want your help. I don't want to go to the hospital. I want to go to the doctor. I don't care if I die. And they were of sound mind, able to make a rational, clear decision. The medics that were there on that scene, I was supervising, they called me and they were frantic because they're like, what do we do? This guy needs to go to the heart hospital or he's going to die. And I had to explain to them, it's his right. That's his choice. He has the right to decide what happens to his body and what he accepts and what he doesn't. It was very difficult because this gentleman didn't want to go to the hospital and get help. The medics knew he was in grave danger. His family knew he was in grave danger. The family was begging him. The medics were begging him. He didn't want to go. The ethical dilemma was, do they force him or do they let him stay? Well, legally they had to let him stay, but it sure was an ethical dilemma for those guys. So there's all kinds of things that you're going to come across in your career as an EMT that is going to be an ethical dilemma, that you're going to have trouble deciding on or figuring out what is the right course of action. Usually the best thing to do is to get more people involved to help you make that decision. And that way, if you're ever questioned about that decision, you can go, here's what I based my decision upon. And then you can kind of lay that out. So you're going to come across those situations where you're going to have to evaluate and apply ethical standards, not only your own, but those of your profession. And that's when you really need to call in, your supervisor or a trusted EMS friend or that kind of thing to help you make that decision to do what's right. Of course, also you need to allow for rules, laws, and policies to guide your decision making. Sometimes those things guide us in what we need to do because it's kind of black and white. But you're going to have an ethical dilemma. You'll have a few of them. If you ever have to go to court, oftentimes you're called into court as a witness. Let's hope you're not a defendant, but typically medics are called into court as an expert witness or a witness to a situation or that kind of thing. Sometimes you can be a defendant as well. Obviously, whenever you get called to testify, you're going to get a subpoena, and those are almost always delivered by a sheriff's deputy. Notify your service director and legal counsel. They'll help you kind of navigate the waters of that. As a witness, it's your job to remain neutral. It's really good to review the run report before you go to court because honestly, when you're a witness to these things, usually it's months after the fact. I had a gentleman from the United States Attorney's Office in Washington, D.C. fly down to visit with me about a call that I had went on 11 years ago that was a shooting. It was a homicide. And I was completely lost until I got my hands on the run report and was able to sit down with that attorney and provide some very black and white things for him that I think was very helpful to his case. I was fortunate that I didn't have to testify in court on that particular deal because I think once they seen the evidence that was against him, they pled guilty. So, and that come back to good report writing. I asked the patient who shot him, and he told me. He told me the name of the person who shot him, and I wrote that name in my run report. When the district attorney, or when the U.S. attorney seen that, he said, this was amazing that 11 years ago we had, a dying declaration from this person about who shot him. There's a long story about how it wound up taking 11 years, even though we knew the name of the person, but it was a very complex deal. But the guy wound up life in prison. But as a defendant, you get an attorney, and of course there could be statute of limitations. There may be some immunity issues, contributory negligence, and that kind of thing may be there. May be part of that, and your attorney will help you navigate those waters. And the attorney, if you're on duty, your employer should provide your attorney, but don't be afraid to get your own attorney either, if you feel like that's going to be in your best interest. And sometimes it is. During the discovery phase, both sides are able to obtain more information through interrogations, either written or questions, or depositions through oral requests or questions. I've sat through a few depositions. Most of the time, the depositions that I've sat through were the prosecuting attorney deposing me. The defense attorney had the option to, but typically they didn't. But you could get deposed by either the prosecution or the defense attorneys in these cases. It all just depends on what the case is and what's going on. Could be any number of things. The thing to remember is you're going to court. It's different. If they don't settle this out of court, it's going to go to trial, and it could be a jury trial. It could be a judge trial. There may be damages awarded depending on what it is, or somebody may get sentenced to a prison sentence. Of course, like I said, any EMT charged with a criminal offense should secure services of a highly experienced criminal attorney immediately. Don't count on your job to do that. If you've been charged with a crime, get your own attorney and take care of that. Remember, though, that you're going to court. This is a place where you need to be on your best behavior. You're the professional. You need to behave like a professional, and be prepared, to answer questions in a sometimes highly emotional situation or a highly emotional issue.